Shit. I got to pull up the. Oops, sorry, I didn't mean to cuss.
Yeah,
Um,
that's a good way to start the meeting.
I'm
No, I
sorry, I
think
never heard that word before.
I believe, Warren, you're probably you would probably want to advise the subcommittee members of their duty under the State Government Ethics Act to avoid conflicts of interest and to note any conflicts of interest at this time.
that's what I said. Yes. There being nobody with a conflict of interest, let us proceed. So you sent us a bunch of stuff, Brian, including a draft opinion, which looks good to me, but we obviously we need to talk about it in light of uh, while we may have started talking about this since we started talking about it, several other states have opined and moved forward too, and it looks like we are on pretty much the same track that they have all been on towards this. But do you want to tell us what you were thinking, Brian, and as far as putting this together and where you see the pressure points? And
Sure. And yeah, the I'll say as far as the other jurisdictions that have issued something, I'm happy to see that there's no knee-jerk reaction of lawyers cannot use AI. I think the general sentiment from other jurisdictions, even folks that I've just talked to, or the jurisdictions that are actually issuing some sort of draft opinion or whatever, is that, yes, it's another resource. It's potentially a very effective resource. It's a potentially very dangerous resource. And lawyers that don't use this stuff competently and kind of take ownership of the work product are doing something wrong. If you're going to use AI to assist in your provision of legal services, then it's on you. Just like so many other things that are out there. So I feel like that general sentiment is really kind of the consensus for those that have offered an opinion, and not necessarily just a straight prohibition on using AI broadly. So when we get into the opinion itself, and I'm going to go ahead and share my screen. I'm going to also note really briefly that it looks like, I don't know if we're actually streaming because I got some error message. So if anybody's wondering where it is on YouTube, it's not working here. Nevertheless, that said, so we're looking at the opinion. Really, this background section was one of the hardest that I had to draft for this one. Just what the heck do we want to say in describing what AI is? It's so broad, and it can mean the smallest thing or the largest thing. So I ended up with some help from Jeff Kelly, who's been involved with some bar committees before, and I know is working with Legal Aid and their innovation lab. He and I gave a presentation to the Bar Association back in I guess it was early October, and just trying to kind of overgeneralize what AI is, but just to kind of say that yes, it is this. It's this machine-based system. It's given human-defined objectives. It's algorithms, what have you. It's enabled to solve problems for decision making based upon a set of parameters that the programmer gives. I try to just kind of encompass all that could be in AI while also recognizing that this term remains evolving. Because I think one of the dangers with this type of opinion is drafting something that becomes outdated very quickly. And I'd like to think that the definition that I put in here kind of, I guess, allows for that, recognizes that what AI will look like in 2033 may very well be different than what we have in 2023. And by then we may have a completely different opinion. By then we might not have a legal profession. Who knows? We'll find out. but the
might not
bottom
have a
line,
state bar.
yeah, I might have a state bar. But the first inquiry, just kind of jumping into the broad question that we have received on the ethics staff, whether it's actual calls, emails, or somebody pulling me aside after a CLE of just, are we allowed to use AI? Yeah, you can use AI. and trying to set that stage. A lot of this stuff was kind of based upon what I previously had written in. I think it was a machine learning based opinion or inquiry from 2021, as well as that article that was published in the State Bar Journal. But just trying to kind of tease out that if a lawyer is going to use AI, I feel like this first paragraph is really kind of the main one. You have to use it competently. You need to protect client confidentiality, and you need to properly supervise whatever the work product is from the AI employed. This is where I guess I'll say I saw some other jurisdictions. I believe Florida kind of goes into more detail with confidentiality. I didn't feel like we needed to get into, the duty of confidentiality is a very broad duty or anything like that. We recognize that. We just kind of get into the gist that, yeah, lawyers have to handle things competently. Competency includes being aware of technology. We have a duty to make these reasonable efforts under 1.6 to prevent the inadvertent disclosure or unauthorized access of this confidential information that is entrusted to us. And then 5.3 kind of puts us in charge of whatever the non-lawyer assistants working with our firm do, provide, however they act, and try to make that note here that 5.3 doesn't neatly and clearly apply to AI, but the principle does. And I'm going to just kind of pause on to note a little tangential thought. Should this committee, perhaps after the publication of this opinion, consider whether there needs to be an update to Rule 5.3? That 5.3 is an important rule, the lawyer's responsibility for non-lawyer assistance, but should it be expanded to recognize that there are different processes, particularly machine-based processes, that the lawyer still has a duty to supervise and make sure that those processes are compatible with the lawyer's obligations. It's kind of I think it's in my mind, I feel like we could expand it in that regard, but I think it's worthy of some discussion. Certainly, I don't know if it needs to be its own separate rule, or if it should be lumped in with 5.3. But it's just kind of an outside thought that I think maybe we should explore after this opinion. So again, this first opinion is just asking and answering the question: can a lawyer use AI? Yes, you can. Do it competently, do it securely, and you're going to be responsible for whatever we have. We can get into some details. I'd like to hear your thoughts on the content of these particular inquiries after I just give this quick overview. Inquiry number 2 just kind of talks about the third-party company's AI program, i.e., it's not your own program that's in-house. We're specifically talking about using somebody else's AI. As you can imagine, there's going to be such a land rush for AI territory and the function for whether it's drafting, analysis of whether e-discovery, all this kind of stuff. There's a lot of stuff that's out there, a lot of potential, and so a lot of it's going to be done by third parties. And I think lawyers are going to, and they have to ask the question: can I send my information, my client's information, to another company? Which we've already answered that question before. Yeah, you can upload your client's information to Microsoft's OneDrive. That's okay as long as you have taken the steps to satisfy to yourself and your own obligations to make sure that is a secure place to land. It was one of those things, I think, that topic of cloud computing. I remember we actually did receive an inquiry one time about somebody who wanted to use their friend's cloud service, and all the servers were in the guy's basement. It was out in the western part of the state. It was one of those things where it's like, yeah, that's a form of cloud computing, but you need to really satisfy yourself that this person knows what they're doing. And it's one of those things that feels like a very obvious answer, mostly because, like with regards to cloud computing, mostly because the big providers are huge companies. But there are those little companies, and there's going to be these little companies that pop up with a new AI process that lawyers will need to go through this analysis. So I think inquiry and opinion number 2 are important just to point out if you're giving confidential information to another person, this has been done before, but there's still these same considerations for artificial intelligence. Inquiry 3, my goodness, I realize I need an here as opposed to just an A. If you have that software developed in-house or by a third party, but it's kind of conformed for in-house use, that doesn't change the data security requirements. And I think this was one where I was thinking of ChatGPT. ChatGPT is clearly came out with its public resource first. That's what made the big waves, but it's now getting to the process of essentially using its core as a platform for client-specific or consumer-specific tasks or programs, analyses, anything like that. And I know sometime, I believe it was just in October, where they came out with a, the name is eluding me now, but ChatGPT Enterprise, I believe it's called, where it's supposed to be a more secure form of using ChatGPT as the basis. It's almost like ChatGPT is the equivalent of Android, Google's Android platform, but they're going to use ChatGPT as the basis for a state bar specific AI process in, initially reviewing grievances or whatever it may be. And they are creating new products that are supposed to be more secure, that does not send information that you put in on your firm specific product back to ChatGPT for further training and use. So it's again, an evolving thing, like right now, as we see AI programs being kind of utilized in a variety of different ways. Inquiry 4 gets into this question of, just if you're signed, I think it's kind of it's the New York situation where a lawyer signs a pleading based upon AI. What is, just because you've used AI, does that somehow relieve you or change your obligations that ordinarily exist when you are submitting a pleading, signing your name to a document, whatever it may be? No, it does not. It's the same thing. And I think that was kind of an overall theme that I was trying to achieve in this opinion, of trying to say AI it's new and it's not. Our reaction to it, it's a new technology, but our reaction to it really is the same. Nothing has changed drastically with regards to lawyer obligations. We're still responsible for what we put our name on. It's just, how we got there. Inquiry number 5 asks this question of if a lawyer is required to inform the client that they are using AI. This is the only inquiry where I answered that it depends. And I think it depends because it's the question of how you're using AI. How critical is AI? Do you need to say that you were using AI to draft a lease agreement? I don't think so, not personally. Just like you wouldn't need to say, hey, listen, my paralegal is going to be taking the first draft at this. I don't think there's any requirement there. But if you are relying upon AI's analysis of, say, similar claims in Mecklenburg County to kind of present to the client, I think we need to pursue this particular pathway, or I've analyzed these different, Craig, I wonder about, like, with real property issues, how many different, whether it's title opinions, whether there's different kind of trying to negotiate the sale of commercial property or whatever, and trying to evaluate the different contracts using AI. I don't know exactly how that would work. I know somebody asked me one time about utilizing all the data points that you can find in the Register of Deeds to try to, like, analyze your potential success in pursuing a particular property for this amount of money and under these conditions. They were basically going to have AI read all these different lease agreements and try to spit something out about a potential claim. I feel like if you're using AI as kind of a material source of information, maybe that would be a good thing to tell the client. I'm basing my information, I'm basing my advice on this process. And frankly, I think that'd probably be impressive to the client. But that's why I kind of said it really depends on how you're using it. And that's as much based upon this 2007 opinion that we had. 2007 FEO 12 that's noted here in opinion 5 asked this question of when a lawyer outsources work to another country. I think the scenario was lawyers sending work to India or something like that. And whether or not lawyer has an obligation to say that, this was initially drafted by folks that are not in this country, but I'm utilizing their sources, their resources, their individuals to kind of get us started. And that opinion said that there was an obligation to let their clients know that this information there, excuse me, that the legal services were being supplemented by foreign resources. Without getting into whether or not that opinion should or should not stand, I'll just say that opinion is out there, and so that's where I kind of based my answer here in opinion number 5 of it depends on. Inquiry number 6 gets into the billing question, which I think is a straightforward thing. I know we've talked about billing a lot these past 2 years. And this one basically just kind of says, if a lawyer is able to complete an ordinarily 3-hour task in 1 hour, then lawyer cannot bill for 3 hours. You can bill for 1 hour, and the efficiency you've created allows you to do more work for more clients, but you can't say, well, this really is a 3-hour task that I'm now completing in 1 hour, so I'm going to bill you for 3 hours. But the opinion does go on to kind of say that, lawyer can consider a flat fee. They may want to move to a flat fee process as long as it's not clearly excessive, as long as the client consents. After reading the Florida opinion, I drafted this provision up that I'll be happy to send to you all. But I just drafted it this morning. That talks about expenses. The Florida proposed opinion talks about a lawyer using AI for a particular client and charging the client for the expenses incurred in employing some type of artificial intelligence process for a particular client. What I've added here basically says, if you've incorporated AI into your law practice for case management, maybe drafting assistance, generally it's something that you rely upon for almost all of your clients, and you never know exactly when you're going to use it, but you have a subscription, a monthly payment that you make, something like that it wouldn't be appropriate to charge an administrative AI fee to every client just because you did or might use AI in the provision of legal services. But if you say have a client, they have a very specific case, and there's an AI program out there that would be very valuable to your provision of legal services to that client, and you pay maybe it's a one-time fee, maybe you pay a month, you get a monthly subscription, but you cut it off as soon as the representation ends. That's the type of expense that you could charge to the client, provided the client consents to the charge. It's not clearly excessive, and it's accurate. You can substantiate it because I'm providing services to client A to help client A's case. I have taken out this monthly subscription of $20 a month, whatever it is, and as soon as it's over, then I've discontinued it. I'm only using this AI for this particular client. I think that's an expense of the representation. As long as the client consents to it, then I don't see why you couldn't pass that on to the client. So again, I'll send that over to you all, but that's the general gist of getting into this question of what can you charge a client with regards to AI. There's the fee question, but then there's also the expense that you might incur in employing AI for a specific client. And I wanted to include that after reading that Florida opinion. So that's the overview. I know that's a lot, but I'd love to, maybe we can just start at the top and say I'd love to get everyone's thoughts on this.
Well, Brian, I'll start just to kind of get the ball rolling and tell you that we have entered into an agreement with a third-party provider at our firm. We've got a pilot group that is composed of people in various practices. And we entered into a specific confidentiality agreement with this provider because we didn't want client information to be kind of cast out in the generative atmosphere, so that what's happening with our clients is used to kind of develop responses and other contexts for other clients apart from Parker Pose. Just in terms of the experiences that we're seeing, by and large, people in litigation type settings find this to be much more useful than those in transactional settings. But at any rate, I know you deal with the confidentiality aspect, and we felt like we really needed to be very, very proactive on that and enter into something in writing that kind of prohibited this third-party provider. It's a Thomson Reuters product called CoCounsel. I think I've shared that on prior calls. But that's been a good thing for us in terms of helping us feel good about confidentiality. And by the way, I talked with our firm's AIs over lunch about these issues. And when I kind of shared with him what had been kind of recounted in your document, Brian, he was very complimentary. He said that this really does appear to be well done and deal with most of these issues that come up for law firms. And so maybe I'll just stop there because I know you may be wanting to go inquiry and opinion by opinion, but I just wanted to share those overarching thoughts here at the outset.
I appreciate that, Craig, very much. And that's I as far as the a third party that was getting into opinion two. So I guess, am I hearing or understanding you to say that you felt that there was nothing in opinion two dealing with providing or using a third party for AI services that was either kind of different from what you all were doing or would otherwise kind of redirect your actions? It sounds like, it sounds like your description is exactly what the opinion is talking about.
Yeah.
Make sure it's secure, make sure that, it's not sending confidential client information back to be trained upon and all that. Or was there anything that maybe is more or needs to be more explicitly teased out to be helpful to folks?
You could have some more specificity there, it seems like, Brian, because we felt like, these are kind of general themes that you're outlining here. And this is a practical way to let the law firm feel, or the practitioner feel, like they do have something in place that protects confidentiality. You might throw out as an example something like we've done, or anything else that you've heard of other firms doing. But it seemed to me that that was a way that we could have some assurance that this third-party provider understands that anything that we share can't be disclosed to anybody else.
Craig, so with Thomson Reuters, they're developing, or you're contracting with them to create something just for Parker Post, such that any inquiry that Parker Poe makes on based on any information, whether confidential or otherwise, that Parker Poe feeds into the inquiry through that inquiry, and anything in that inquiry is not shared with the rest of Thomson Reuters for the law firm down the street. Is that
correct? Or anyone else,
or anyone else, right?
Yeah,
but I guess
it's really specific to anything that we share. It goes into the, I guess, portal that Thomson Reuters has, and then hits a hard stop. There's no sharing of that anywhere else
beyond that. So it'll respond to that particular inquiry based on what it has, but it won't take that inquiry and add it to the database for responding to future inquiries. Gotcha.
Yep. So if Lamar has some similar situation, or his firm does, he and that firm won't get the benefit of whatever the analysis was, or whatever the factual circumstances were that we had shared with Thomson Reuters.
That's cool. Do we really address that type of scenario and the difference between inquiry 2 and inquiry 3 there, Brian?
Yeah, I think actually inquiry number 2 was using a third party's tool. Inquiry 3 is the one where we have a third party's tool that is kind of conformed to a specific firm's needs or requests. And that's where, we have this, I've got this last paragraph here in inquiry 3 that basically says that, these things that are developed in-house for a particular firm may be derivatives of a particular program. And some of these customized programs may continue to send information inputted into the firm specific program back to the central program for additional use or training. And that's where I put in there, that it's up to the lawyer to educate themselves about how that thing operates and to ensure client information will remain protected in accordance with the lawyer's professional responsibility. I'm thinking that maybe it could be a bit more direct there in saying that, confidential information should not be sent back for further training. Like it needs to be more specific, rather than just, hey, educate yourself about how it's going. But yes, educate yourself and ensure that the confidential client information put into the program, the firm conformed program, does not go back to the more public facing, or just kind of I don't know I called it a central program. Not sure if that's the appropriate term, but that's where we kind of address that particular point. Ellen, I see. Oh, sorry. Yep.
So I do wonder, and I assume actually that with Parker Poe, it just stops all information from going any further and wouldn't make a determination as to what's confidential or not confidential. And I don't know for smaller firms if there are options out there that offer that. With bigger firms, of course, you have more power and more money, but I don't know for smaller firms if there's a stop that you can put in place. I do think that with the Florida, I liked the way they set out. It's like 3 dots in the opinion under the confidentiality section, where they cited some of the other ethics opinions. It was Florida, New York, Iowa, and then they said to ensure the provider has an obligation to preserve the confidentiality and security of information. The second is investigate the provider's reputation. And the third, determine whether the provider retains information submitted by the lawyer before and after the discontinuation of services, and asserts proprietary rights to the information. I liked the way that the opinion set that out. It almost creates a checklist of things you'd have to do. And so if there is an ability to be more specific and maybe even add in that into that part, or can block all of the information from going past the service just requested or for which it was contracted, so that it doesn't go into a general database. And I also, under that confidentiality, had flagged, let's see. Oh yeah, that we have a duty to learn whether or not the program is self-learning, so that we make sure to ask about the data. I really like, particularly for people who are not as familiar with AI and who are just beginning to use it and may not fully comprehend how it works. This alerts them to these are things that could be happening when you input, that they may otherwise not be aware, that their information is going into a big database as well. And just one other thing that I made note of, if we can move away from the confidentiality issue at the top, at the very top, when you define AI, you say it's client specific, and I don't think that AI is always client specific. And so if you scrolled up there, it's just one, the definition just came down, or your opinion just came down.
There we go. Now it's back.
All right. Okay, just the last, the very last three words when you of that first paragraph, when you say, based upon the lawyer's input of client-specific information, I would probably say based upon the lawyer's input of information that is sometimes client-specific.
Right. Yeah, here I was trying to list it as an example, but I kind of jumped to the more extreme example. But I think you're right that it could be information that is both client specific and generic, and Lori, I feel like you're
Right.
hitting on one of the points that I was struggling with. The question of how much in this opinion should we include to educate readers on AI? And I think that's like the self-learning aspect of the Florida opinion, where they explain what generative AI is. Yeah, it can be really helpful, but then does it potentially age the opinion quicker, especially if it changes? I struggled with that. Truly. And I see
So,
Lamar. I know
I
Ellen
think-
got it. Yeah. Go ahead.
I think that most of us, particularly those of us who aren't just coming out of law school, are just making ourselves familiar with what AI is. And so if you aren't going to have anything more specific in the opinion itself, you might reference or create a separate document that you could reference in the article, or in the opinion, that you could reference an article that might give more specific detail, like a dummy's guide to AI or something.
Yeah.
Something like that. I wouldn't actually call it that, but just so people really know what to look for. It's part of why I joined the committee, so I could learn more about it, so I could make sure I was complying with the ethics rules myself, but I'll also just to bring kind of a novice's point of view to the committee.
No, I think that's really good. I think we can absolutely find a good reference and put it as a footnote, or maybe not even as a footnote, but just to kind of put it in the background section, to understand more about artificial intelligence. That way I don't want people to just kind of scroll past a footnote. If we want folks to learn about it, here's where you can learn more about AI as it is today. And hopefully that article will kind of give some good prediction on where it's going. I saw Ellen had her hand up a while back. Ellen, do you still?
Or as it existed at the time of the writing of this opinion. Yeah.
Right.
Oh yeah, thanks, Brian. First of all, I think this is just fantastic, and I think I'm really glad that we're doing it now. I have a couple of thoughts, but what we're talking about right now, I do think there needs to be more educationally, and I think it should be in the opinion. And I know it dates the opinion, but I think the difference in generative AI and not is it's not just a detail, it's really key. And I think it's key to how the rules apply. And if you're using a third-party AI chatbot, right, just to do intake, it's very different than if you're using the system that Craig is talking about using at Parker Poe. And so while I don't want to bog down attorneys I think if we expect them to educate themselves, then I think Lori's point and your point that, we have some responsibility to do that. And I think an opinion like this becomes much less useful, even if it has a longer shelf life, if it doesn't come out of the gate and say, there's generative AI and this is how it works. And this is an example of how, I don't mean in these words, but this is an example of how lawyers are using it, because inputting confidential information in that is different than doing it with other AIs or doing a search in Westlaw, which was running on an AI before they launched their generative component.
I agree with Ellen to the extent that, like at the end of inquiry number 2, where we say generally, as of the date of this opinion, lawyers should avoid inputting client-specific information into publicly available AI resources. Well, there's Westlaw is publicly available.
Yeah.
You can punch, we do that every day, but it's different than me pulling up Chat GPT and punching the same information in. Westlaw is just, it's not learning from my input so much for the standard research as Chat GPT is taking my input, it's taking its output, my subsequent questions about the output that they give you back into it to tweak it, and it's learning from all that. There should be some, I think, generally you can use AI resources. Because we're doing it already. As long as you've done all your due diligence. But I would also think generally you shouldn't be able to use Chat GPT, the publicly available version of it, without client consent or something. That's, I don't know. I'm just wondering whether we need to be more specific about the ways you look at the two different types there.
Yeah, well, I'm realizing that I think the term client specific information, I think I need to change that, because I was more so referring to client identifying information or identifiable information. Plugging in your client's legal issue into Westlaw, searching for case law, is client specific information because it's their issue. But with generative AI, you're saying draft a brief arguing this point, a motion for a summary judgment. Here's the case caption. Here's the, put it all together.
Here are the facts.
Yeah, for the facts. That's right. So that's where it's much more, it's more specific. It's really, it's attributed to the client specifically in a way that identifies the client. So maybe that's a tweak that I need to go with. I don't know if anybody else has any thoughts on that. Client-specific information is perhaps too broad, as opposed to client identifying information.
And on a similar
I
vein,
think that would be
go
a
ahead,
good
Ellen.
clarification to make, because I wondered that myself.
Well, on a similar note, differentiating between just AI versus generative AI. And I think it's inquiry 1 on the middle paragraph on the second page. We say a lawyer's decision to use and rely upon AI to assist in the lawyer's representation of the client is hers alone, and one to be determined based on a number of factors. I think that's not necessarily true. If you're using generative AI, you may, once again, need to talk to the client about that before. And we do say that later, but that perhaps you, depending on the circumstances, like I think it's under number 5, whether you need to get the client's consent. But you may have to, and maybe that's where we make the differentiation between just regular old AI algorithms like we used to have versus this generative AI. Is that getting to kind of what you were talking about, Ellen? The
Yeah.
concerns?
Yeah, I mean, I think Craig taught me this term, but I think it's extractive AI, where it's an AI that, you know, it's Westlaw extracting from what it already has, right? As opposed to taking what, you know, Warren puts in it and then adding that to it, and then, right. I think that's right. I mean, that's a Jeff Kelly question, but and I know that dates the opinion. I know that, but in terms of usefulness, I think it really enhances it.
All right, that's helpful. Let me ask, and based on what you just said, Warren, this question of, you know, and I see the kind of the contradiction that you've just pointed out in inquiry number 1, saying that it's basically the lawyer's decision to use AI, but then later on, whether or not a lawyer uses AI or what have you, whether they have to disclose to the client their use of AI depends. And so maybe that needs to be teased out better. But that general question of, does a lawyer have to inform a client that they're using AI? This is inquiry number 5. Do you all think the answer of it depends, like what do you all think of that? Because that was another one that was kind of a sticking point in my head. Part of me thinks, well, you know, maybe you don't need to advise the client because it's how you're providing legal services, the way that you don't tell them how many paralegals you have. I don't know. What do you, Ashley, did you have a thought on that?
Yeah, I thought that answer was good.
Okay.
I've got a question about inquiry 5. It seems to be backward looking instead of forward looking. Maybe that's a big deal. Maybe it's not. Do you want to, I'm just thinking about the way you practice. Do you want to kind of mention that you may use AI in connection with whatever engagement client kind of asks you to help with? Because this seemed to be, okay, you've got the matter in the door, you've done the work, perhaps you've used some AI, and then you need to tell the client that you did that, as opposed to on the front end, maybe in an engagement letter saying something about that, you know, depending on the type of work that's required in connection with the engagement, you may make use of AI.
Right.
I'm probably not explaining that very well, but
no, I know exactly what you're saying, Craig. And I guess that's, I mean, truly, these are some of the questions that I've wrestled with. Of, yeah, do you, on the front end, do you have to say, and is it enough to say in a fee agreement if you do have to say it? But do you have to say, hey, I may use AI? Is that something the client they should know? Does it depend upon the type of case? Or is it something that, you know, the client has retained the lawyer to provide legal services and they're looking for a particular result? And if your analysis is based upon something other than your own work, you're relying upon AI to do it, that might be the trigger of communication. And that is kind of, like you said, it's backwards looking. It's, I've already done it. Now I need to tell you so you can make your informed decision, client, about what I'm advising you. But does it need to be kind of a prospective disclosure that I may use that? What do you all think of that?
Brian, this is Ashley. It just seems overburdensome to me to require a lawyer to tell a client that they might be using AI. I mean, I just think that's extremely burdensome. I think that the other inquiries make clear that if you use AI, that you're responsible for the product that you produce, you're responsible to your client, and then that there are certain, you know, the substantive tasks have to be disclosed. I think that's right. I think what you have, I think that's right. I think that, I mean, you know, you've broadly defined AI as pretty much using a computer. I mean, it's a lot.
Actually, what would a substantive task be? In other words, I don't see disclosing beyond, I don't know why a lawyer would have to tell her client unless she needed to get informed consent to do something that already requires informed consent under the rules, like disclosing confidential information or something like that.
Yeah, I don't disagree with that. I didn't read, Ellen, I didn't read that 2007 FEO 12. I assumed that language tracked it.
Oh, I see. Okay.
That's
okay.
quoted there
Yeah.
because actually, I've done a lot of I did like a 1,000,000-page document production that lasted several years. And I mean, you work intimately with document companies to review and produce that information. And I mean, it is a substantial delegation. I don't recall that. I mean, our client knew we were doing it because they were paying for it. But, I don't recall us doing like an informed consent. Is that required, Brian? And I mean, what about, isn't it the equivalent of sending a huge box of documents to someone to bait stamp and copy?
Kinko's.
What did you say, Warren?
Kinko's, sending it to
Yeah, I
Kinko's
mean,
like we
it's
used
a
to do.
lot like, a lot of this AI stuff too, it just makes me think of it. I mean, it's just an electronic version of what we've been doing with paper in some ways. Some of it.
No, and so yes, the answer to your question, Ashley, the 2007 opinion, I'm going to just go ahead and put it, I'm going to share my screen here, because it's one of those things that, again, I don't want to totally derail us, but I think there's a fair question as to whether or not that we still agree with this provision here. But it's here at the bottom. Let's see if I can zoom in better. Finally, the lawyer has an ethical obligation to disclose the use of foreign or other assistance and to obtain the client's written informed consent to the outsourcing. And that's kind of where I was coming from as looking backwards. Of course, this one is kind of I feel like there's at least there's a question based on the language there of whether it's really forward looking, that before you send it over, you have to get the person's consent. But I wasn't there when this opinion was, I guess I was here at the bar, but I wasn't involved in the ethics thing. I think I was maybe working here for about a month when it came about. But I don't know what the reasoning was with that one, because I think you're right, just from a consistency perspective, whether or not I'm asking my paralegal in the next room over or somebody who is over halfway across the globe to take the first crack at drafting something, it's ultimately my responsibility because I'm putting my name on it. And I think that's, to me, and to your point, Ashley, that's what AI is. It's what we've been doing the whole time. It's just kind of an electronic form of it. And so there may be a time when you're trying to say that there's some sort of material aspect of the services I'm providing, and I am basing my analysis not on my physical picking up of paper and putting my eyes on every single word, but instead I asked an AI program to comb through thousands of pages, and I trust this program's work product. I've looked at their end result, and I'm ready to go argue this, but I'm putting my name on it. I'm still responsible for it. I think that to me is one of those things that this 2007 opinion, this last paragraph, is kind of I guess it's a curious one to me. Like I said, I'm not trying to derail us and say, hey, should we go and edit this opinion again? But that's kind of where it came from.
Well, Brian, I think one of the other things that's really an issue here is the blending of Inquiry 5 with Inquiry 6, where one of the things we haven't talked about is how do you bill? And I don't know of many firms, and I'm not saying my knowledge is comprehensive and exclusive, but my guess is over time, the way people are going to bill is not by kind of the way that maybe firms have billed Westlaw in the past, by usage. And I think they're going to have to figure out, okay, how do I capture the value of what I'm providing. And I bet it's going to be on a fixed fee or flat fee basis, as you've alluded to. And at the end of your opinion 5, you kind of touch on this. If the decision to use or not use kind of impacts fees, the client needs to be part of that. So again, I'm kind of anticipating where I think the profession may end up on it. And maybe I'm right, maybe I'm wrong, but I believe that you'll probably see a higher incidence of flat fee or fixed fee billing as a result of what AI has to offer. Because if you don't do that, I think you may find that the practice becomes very different than it is today.
Yeah, I agree. And I think you're right there. That's kind of the transition point of, if you're using AI to do your work and it's somehow impacting the fees, then there's always, I think it's going back to the principle that if a lawyer is going to charge a client for something, I guess, I don't know, almost just kind of differently because of AI, not necessarily, I guess that's too broad of a statement. If you're reducing the amount of time that you're doing, I'm only charging you 1 hour instead of 3 hours because of AI, I don't think you have to disclose that. But it's more of, if you're going to charge somebody the fees that are associated with your use of AI because they're specific to the client, that this is that that new paragraph that I just drafted this morning, I sent to you all.
And that was a good ad. That was a good ad, in my opinion, because I think that's a place where we needed to have this.
Yeah. That's gonna require a conversation. If the client is going to be on the hook for the bill, then yes. And you're right. It's not the same as, how many searches did you do on Westlaw and assigning the client to him? It's going to be a different thing that we don't know how it's going to look. But I think that's I don't know. I think it sounds like I'm hearing that as far as communicating with the clients, that it doesn't sound like there's an appetite for this prior disclosure of potential use of AI. It's not like we have to tell the client, hey, I may use it, or even I do use AI as a part of my case management system, or whatever it is, which is going to be responsible for me telling you when to be in court. That's overburdensome. I just don't think that's necessary. But it really, the disclosure comes in. I think that's what I was looking at. Rule 1.4b, that requires lawyers to communicate with clients so they can make informed decisions. We have to basically empower our clients to make the informed decisions that they need to make. And so when you're relying on AI to conduct some critical part of the analysis that's associated with the legal services you're providing, and like I said before, it's not lawyer has gone through 2,000 pages and has found every single thing, and this is where their analysis, but instead they fed it into a machine, got a result 15 seconds later, and they say, well, I think this is a good machine and this is the result. Even then, I question whether or not, do you think lawyers have to disclose that? Maybe we don't think they need to disclose it at all, unless it's actually impacting the bill. But I don't know. I guess I know I'm kind of raising more questions without clear answers. I'm kind of giving you a window into my questioning mind as I was drafting this thing. Nevertheless, Lamar, you've been quiet. I'm wondering what you're thinking.
Yeah, I'll hit that point first, and then I got general thought. I seem to agree with this hesitancy to impose a duty to provide advance informed consent. Because, really, when you say lawyer is relying on AI to generate work product, what does that really mean? Well, we described earlier how it's ultimately lawyer's responsibility, whether to your analogy, we're spitting something in the machine and we get something back 15 seconds later. We already make it clear over and over again, right? I'm not saying this, but overall in our opinions, that it's ultimately the buck stops with us. So whether you're using AI or not, you still have to independently verify the accuracy of what it says and so on and so forth. And so that duty exists regardless of whether you're doing your own manual research at the courthouse or using AI or anything in between. So I think we cover that through the emphasis of other duties elsewhere in the opinion. So I would echo at this point, maybe it changes in the future, but I'd be hesitant to jump all in on advanced informed consent. More generally, my thought on all of this, it seems to, well, first of all, I want to know, did you use AI to draft any of this opinion, Brian? Because I know
No,
you
I
did
didn't.
some of your...
I actually did not. I thought about it, but I didn't.
Okay, that's good. It seems to me that you've done a remarkable job of this, but you've got these tensions between the general and the specific. And what I mean by that is you've got the general baseline duties, confidentiality, diligence, and so on and so forth, that are easy to state, but then hard to apply. And the reason they're hard to apply is because, as you said, it's constantly evolving. And if we put specifics in here today, it could be, old news by tomorrow. So someone earlier mentioned, a little bit different, but mentioned the idea of having a separate document. I really like what California did. They had like what they call, I can't remember what they called it. It was like a working document or a living document that was separate from their main opinion. The main opinion is devoted to more addressing the general, things that aren't likely to change, emphasizing we got a duty of confidentiality, got a duty of diligence, even including AI. But then the specifics of what that means based on today's AI. And maybe that's just because California's got more staff in their state bar association, or more, I don't know, more hands on deck. And so they can have a task force that constantly updates this living document. I don't know. But if there were ever a situation, in my mind, if there's ever a situation to have sort of a more general FEO that emphasizes that our duties of confidentiality, diligence, and so forth apply to AI, and you can't just spit something into a machine and use it without double checking and making sure that it's confidentiality, client information, and all that. But then have a more specific living document that is going to change over time, and that seems to me to be a more workable solution than to provide more specifics into an FEO just to have to revisit it, however much we're going to have to revisit it. But again, that may not be realistic for our setup. I don't know. But I just sort of like that approach. Keep the general, keep the specific in a living document, that we have some sort of standing committee, some sort of something that can constantly update and revise as we move forward. And to that end, I read in one of these materials that the ABA has a task force that I think it's anticipated they're going to come out with some report, AI report or something. And I don't suggest that we just sit around on our hands and wait till they say something, and nor do I suggest that we have to necessarily follow their guidance. But at the same time, it would, I think, certainly be helpful for this committee to see what they have to say as well, I would think.
My understanding, Lamar, is their ethics committee's working on an opinion.
And Brian, I guess you've not heard anything in all of your...
No, I haven't. I'm not as plugged in with their professional responsibility committee. I'm like, I'm part of the section, but I haven't been involved with the committee. But still, yeah, I think that's going to be one of those things that I agree. It's that question of, how long do you wait, and if you disagree with it, what do you want to go with? So I really like the idea of having these resources that people can go to. And what California refers to is this thing out of MIT. They've got this page that just has a lot of different resources. That might be a great thing to reference here. This is almost like an opinion that is we can have some education. I think to Lori's point earlier, having some education would be a very helpful thing in the body of the opinion, because that's what gets read. But then if we want to make more resources available, maybe this opinion has an appendix of sorts, and just to list these things, understanding, of course, that we have lots of opinions. I don't want to avoid drafting an opinion that's helpful now just because it might age quickly. We certainly have opinions that are aged at this point, and that's okay. It's okay, because it addressed the situation and the principles are still the same. That's really one of the things that I like about our pursuit of this opinion, that this is just a continuation of longstanding principles in a different context, and how the rules can morph and evolve here. So, okay, I know we're past an hour here. I want to be respectful
Yeah.
of everyone's time. I think what I understand right now, there's some desire for education in the opinion, some distinction about how generative AI in particular is just kind of a different ballgame. And so I'm gonna look to include some information there. I think having some specificity. I know Craig was talking about that, for maybe even some examples of what we're talking about when you have a third party that can craft something for a law firm, and what happens to the information, how the information can be sent back to train. I know I reference it, but don't tease it out in a way that's very obvious. And I think there's maybe some presumption of prior knowledge in this first draft. And that's something that that I want to improve on. So I'm gonna go back and edit this thing. I really appreciate the feedback and hearing that it sounds like we have a good foundation.
Absolutely.
And we it's a good springboard. What I would also like to do, recognizing the time that's coming up, but I think we really would like to get this thing out for publication in January. So I am going to, just looking at, I know I've got a number of other meetings and all that. So realistically, I'd like to set a meeting maybe in the first week of January. So we can look at and hopefully send it out, sooner than that. But we can look at that updated, revised draft and see if we can get to a spot where we feel comfortable publishing it in January. So I'll have Lanice reach out to y'all for your availability in that first week of January, if that works for everyone. Okay.
Works for me.
All right. Thank you all so much. Let me stop the share so everybody's not just staring at that document anymore. But I really appreciate it. And actually, just by mistake, I ended up clicking on the summary button, which pops up saying enable meeting summary with AI companion. I didn't realize Zoom had added AI to review all that we're talking about and sending meeting summaries. So
wow.
next time, right? All right, y'all.